Okay, let's get started. Welcome everyone to the Utah Law Review Lee Teitelbaum Symposium. I'm glad everyone could join us a little early in the morning, so we're going to have more people join us as the day goes on. I'm Jonas Anderson, professor here at Utah and also the director of the Law Review. First of all, before we get started, I'd like to thank the Law Review. The students, as you know, may have picked some of the speakers up this morning. They joined us for dinner last night. They've done a lot of organization. Actually, all the organization has been done by the students for this thing. And so take a moment, give a hand to the Law Review for organizing this symposium today. We're going to start, we're going to introduce Dean Kronk Warner. Dean Kronk Warner is the Jefferson B. and Rita E. Fordham Presidential Dean and Professor of Law at the Utah Law School. She's a nationally recognized expert in the intersection of environmental and Indian law. She has taught courses in property, Indian law, environmental law, and natural resources law, and she has supervised the tribal, judicial, and book chapters, also to her credit. She's also a citizen of this Sault Ste. Marie tribe of the Chippewa Indians, and has served as an appellate judge for the tribe and a district judge for the Prairie Band. I'm going to say this wrong, but Potawatomi? No, I missed it. Completely missed it. She can correct it when she's up here. But please join me in welcoming Dean Kronk Warner.
All right, good morning. It is a pleasure to see you all here today, and I'm really excited because we have 145 people registered between in-person attendees and our online attendees, and I think that really speaks to how important this topic is, and so I'm very proud to be hosting it. As was mentioned, my name is Elizabeth Kronk Warner. My pronouns are she and hers, and as I always like to do anytime we gather in this space, I want to acknowledge that this land that we're on is named for the Ute tribe and is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands, and we respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. And I really love that we still come together in the Salt Lake Valley, because historically the Salt Lake Valley has been a place where folks have come, including indigenous folks who first occupied the land here. And they would come and they would share ideas and they would barter and they would celebrate together. And so it seems really appropriate that we continue to do that here in the Salt Lake Valley. And I'm so thankful for all of you to come here and to share your wisdom with us and to participate in today's symposium. Third-party litigation funding is increasingly becoming a very important topic that we're dealing with in numerous fields. And so I applaud the Law Review for picking this as their topic this year. Like Professor Anderson, I want to thank the Law Review not only for selecting this topic, but for their exceptionally hard work in putting together today's event. As the only public law school in the state of Utah, we really pride ourselves as Utah's law school. And part of that means that we are here to present ideas and to share information and to help educate our community on these really cutting edge legal issues. And so what better way than to have our Law Review host today's event. And so again, big thank you to the students for picking this important topic and also for helping us to meet our goal for being thought leaders here in Utah. I also want to thank Professor Jonas Anderson, who, as the faculty advisor to the Law Review, has played a really big role in helping to bring everything together this semester, which I want to acknowledge he's doing on top of teaching 3 classes and chairing hiring this semester. So if you've ever had any of those service obligations, you know that he is not sleeping. So a big thank you to Professor Anderson. And I also want to thank our events team. You might see Chris Monty running around. She has has a floral bouquet jacket on today. She's our director of the events team. Also, Lily is helping us today, and Spencer are helping us today. Hopefully, you'll walk away from today's event saying, wow, that was a really wonderfully run event. And that is a credit to our events team. So I do want to thank them for everything that they do and will do to make today's event a success. So with that, I'm going to turn it back to Professor Anderson, who is going to introduce our speakers for the first panel. Jay McGwitch, thank you very much.
Okay, great. So let's get started. So third-party litigation funding, most of you out there, all the students out there are probably like, what is that? And we're going to talk about what that is today. But just to give you a quick example of what third-party litigation funding might look like, let me tell you a little story. So in 2012, Argentina seized a controlling stake in an oil company in Argentina. It was an oil company called YPF. And 11 years later, in September of 2023, a U.S. district federal judge in New York found Argentina liable for essentially taking the property of the shareholders of YPF. The judge then ordered Argentina to pay over $16 billion to the shareholders for whom the case was brought. But interestingly, the shareholders don't stand to receive one dime of that paid out because they'd auctioned off their claims and they'd been bought by a company called Buford, which is one of the largest third-party litigation funders. And the way we know some of this is because they're one of the few public companies that runs third-party litigation funding. So the claim of those shareholders was purchased. Looks like a screaming deal if they ever collect, which is a big if. Buford Capital owns those claims. They purchased them for $16 million. So if they get the $16 billion, it will be a net return of over 37,000%, which is a great investment if they collect. This is, as I said, a big if. Collecting judgments against another country is oftentimes very difficult, especially one that's near bankruptcy is even more difficult. But that's what's going on. Third-party litigation funders come in, they give money for litigation or that's needed for litigation in exchange for some equity stake in essentially the outcome of the case. So if the parties lose the case, the funders don't get any money. If they win the case, there's a contract which states how much money they get in the case. And this Buford's big deal, but other types of deal have shined a spotlight on third-party litigation funding. Third-party litigation funding is essentially when a third party funds litigation by providing a non-recourse loan, meaning a loan that's you don't have to pay back if something doesn't happen, if you lose the case. And in exchange, they get a portion of any payouts from that litigation. It's a rapidly growing industry. They have about $15 billion in assets under management. And importantly for you students in the room, the big law firms love it. About a third of third-party litigation funding goes to big international law firms. So the 200 largest law firms by revenue account for about a third of the total capital commitments from third-party lenders. The third-party litigation funding industry prides itself on providing financial assistance to plaintiffs that wouldn't otherwise have the ability to pay for their case, allowing them to quickly monetize those claims, and permitting plaintiffs to kind of offload the risk of going through a big litigation and end up losing out. Critics, on the other hand, argue that TPLF takes too much advantage of plaintiffs. They take too much money from them. And there are worries about an increase in foreign governments involved in third-party litigation funding. Recently, there's been a lot of action on the Hill, Capitol Hill, around third-party litigation funding. Lots of bills propose about ways to regulate third-party litigation funding. We'll talk about all of those, or most of those, today. Let me just talk about two important ones that I think will be referenced in today's topics. So one is on the disclosure front. Some district courts, specifically in New Jersey and one judge in Delaware, have mandated disclosure of third-party litigation funding arrangements. So, for instance, if I'm a patent plaintiff and I have received third-party litigation funds, at those courts, I have to disclose that to the court. There's a lot of debate about whether that is right, whether that should be disclosed, whether all courts should mandate this. We'll talk about that today. But also, just last week, very good timing because this has been planned for a long time, but just last week, this committee that essentially makes our civil procedure rules voted to form a subcommittee to investigate whether the federal civil procedure rules need to have some sort of third-party litigation funding disclosure. And so it's not happening, but they're investigating it, which means it is very much on people's radar. So with that introduction, I'll turn over to our first panel. First panel you can see is a very accomplished panel. We have on the panel Cindy Ahn. She's the director of Longford Capital. We have William Marra, director of Certum Group, and Victoria Sahani. She's an assistant provost at Boston University. So please join me in welcoming our first panel.
Thank you all for coming here today. My name is Joe Paunovich. I'm a partner at the law firm of Quinn, Emanuel. I have the privilege of moderating this esteemed panel. So we'll get it started. For our panel, we just had Professor Anderson go over a bit about what funding is, which is a little bit different from one person to the next. And so I don't want to necessarily cover that. But as a starting point, if you have anything to add to what Professor Anderson said about what funding is, I'd please encourage you to do that. But also, is funding something that's been around forever in litigation, both domestically and internationally? And if not, what was sort of the catalyst or advent for it in your views?
Sure. So I think that Professor Anderson definition of litigation funding is spot on. It is when a third party invests in a legal claim and that third party only receives an agreed upon return if there is a successful legal claim. Now, as to your question, has it always been around? In the US, that answer is no. Generally speaking, third-party litigation funding really started in the UK and Australia. I'd say that in the US, and Will, you can jump in, third-party funding in the commercial space has really just started, I'd say, in the last 10, 15 years.
Yeah, and I'm Will. I work as a litigation funder. I've been doing that for 6 years now. It raises an interesting definitional question that I think, especially for those who are newer to third-party funding, might want to think about, right? So Certum and Longford have only been around for a few years, right? But what I would suggest is that the practice of a third party financing the fees and costs of another's litigation is not new at all, and in fact is a celebrated and long-established feature of our legal system. So just to give you a few examples that you'll already be familiar with. The contingent fee, right? The contingent fee is a third party, the lawyer, agreeing to finance a case on behalf of a litigant. Pro bono litigation, right? One of the objections to litigation funding is that it violates this ancient prohibition against champerty. Well, the leading Supreme Court case about champerty is a case called NAACP versus Button from 1963 about prohibitions on the NAACP's ability to pay the fees and costs of a third party. And then the third kind of class of third-party funding that I would point you to would be the class that is explicitly permitted by the legal ethics rules. So legal ethics rule 1.8F, which binds attorneys, right, actually explicitly permits a third party to fund the fees and costs of another's litigation from an ethical perspective, so long as the lawyer complies with the ethical obligations, such as client confidentiality, right? And what are these types of examples that they're thinking about? Not just pro bono litigation, but also parents pay the divorce fees of their clients, of their children all the time. Companies very frequently will pay the legal fees of an employee. Those are all examples of third-party funding. As we get into the disclosure question, we can also look at how those examples have been treated. But I think that although the newness of kind of dedicated funds is relatively new, the practice of a third party doing so, I think, has actually been around for as long as we've had a legal system.
Good morning, everyone. I'm Victoria Sahani. I'll just add that third-party funding has morphed in many ways. So the classic single case funding that we think of as sort of traditional third-party funding still exists and is quite prevalent, but we have a lot of new and exciting structures for funding that aren't just arm's length funder providing money to a claimant to support their claim. So for example, we have law firm funding, where funders provide working capital for law firms to support their portfolio of cases. We also have equity funding, which is where funders take an equity stake in a company as opposed to requiring a return of cash from the award or judgment in the case. And there are many others. So this goes to the definitional question because it becomes much more difficult to define funding as more innovations arise. So we can certainly talk about that more in the panel. Thanks.
Thank you all. That was a very good conversation starter to this, which I should also mention too, if Professor Anderson hadn't already mentioned, if you have questions for the panel, the Slido app, I believe, will push questions directly to me. So if you have them, we'll have a question and answer period at the end, but you can also ask them in real time. So I want to touch back on a point that you made, Will, about these different sort of third-party funding arrangements, which really historically go back a long way. And you brought up a number of, I think, really important classes of cases, whether that be in the pro bono context or contingency context, to kind of take us to the next issue. Modern day litigation funding, where is that being deployed? Is it, do you view litigation funding as being disproportionately large corporate interests, or does it have a role in, for example, access to justice and cases that might not otherwise, might be like more of a David Goliath type situation? And whichever one of you wants to take that first.
So I'll start. So one thing that I think is important to note, and it's part of your question, which I think is crucial, is this distinction between commercial or business-to-business funding and consumer, which would usually be individual human beings, but it could be small businesses or something like that. That's a huge divide in the market. And one of the things that is challenging is regulators don't necessarily fully understand the distinctions, and so often regulatory efforts aim themselves at funding broadly, and so that's one piece of the challenge. I think both are growing, both parts of the market are growing in prevalence dramatically, but in very different ways. And so it'll be interesting to see eventually whether or not we are able to educate regulators enough so that they have more of a nuanced understanding of the differences and therefore can provide more appropriate and tailored guidance.
I think that's an excellent point. There is a very big distinction between commercial and consumer. Longford Capital only does commercial. So when I speak on litigation finance, I'm basically speaking on the commercial front. But to kind of build on your question, Joe, about like who's using it, is it big plaintiffs, is it access to justice? And the answer is yes, right? It's grown, I'd say, in the last I've been involved probably about 7 years, and in the beginning, I would say that it was looked upon with a great deal of suspicion by the larger firms. The firms and the clients that were more interested in were smaller, more in need of funds. It was a go, no-go decision. I'd say in the last 3 years, that has changed almost drastically. Large firms are looking at it. The rates, hourly rates that we all know about, go up to $2,000 an hour. There's a lot of successful companies that still do not want to spend the millions and millions that are required to pursue a claim that they're entitled to, right? So that has really opened up the market in a way that it's not because there are more people in the pot, it's just that there are more people willing to explore it now.
Yeah, I agree with all that. And just to very briefly add one quick point on that, I mean, for the law students, I don't know how, what your thought is on how much a major litigation costs, if anyone wants to take a guess at that. But the budgets we see are $5 to $10 or more million, right? Most companies don't have that kind of money to pay Joe by the hour to do that, right? And Joe has limited ability to do that case on a full contingency, right? Because he's got to finance that, right? He's got to pay all of you to work as his associates on the case. So if you think about historically, you have two ways to fund a case. You pay your lawyers by the hour, or your lawyer does it for you. Most companies can't do that, David versus Goliath. And even if you can, that doesn't mean these $5 to $10 million are best used paying your lawyers, right? A principle of business administration is companies should invest in their core. Well, if your core is making widgets, it's not paying Joe to vindicate your legal rights. You're much better off from a business theory perspective to have Andrew, right, someone from Burford who does this, or Cindy, to bear that cost for you.
And I'll go moderator turn panelists here. I think the 5 to 10 million is probably a low estimate, as I'm sure you're all familiar with. Some of the biggest litigations that we deal with every day where, the recoveries are in the 9 figures, those legal budgets can run sometimes, well in excess of 20 or even $30 million. And so it's a challenging environment, depending on who that plaintiff is, to bite off that big of an uncertainty or risk, where you have players like the funders who are able to step in with a huge number of use cases and reps through litigation and quantify that risk and make a calculated investment where everybody's bearing some of that risk. So let's turn to our actual topic of our panel, disclosure and discovery, which is sort of the hot topic of today. Before we get into some specifics about what we think that should be and where it's headed, I wanted to get each of your views on, what are the policy considerations from each of your perspectives that are driving that question. Do you or don't you disclose third-party funding, and to what extent? So maybe we can start with you, Victoria. Thank you.
Thank you very much. So I'm a law professor, so I come at this from an academic lens, practical but also theoretical. And so I would say that one of the biggest questions is why? Why are we disclosing? And it turns out there's a lot of different reasons to disclose. One of those reasons could be, for example, to check conflicts of interest. So when you have judges or arbitrators, I'll bring in arbitration into this context too, that are hearing cases, there's a possibility that there might be a financial conflict of interest for your decision maker. And the reason that can come up is because many entities are investing in litigation by investing in litigation funders. That includes pension funds, that includes university endowments, that includes lawyers, and in some circumstances, other businesses. And so checking those conflicts of interest is key to make sure that the decision maker doesn't have any impermissible conflicts. As you may have learned in your professional responsibility course, if you've taken professional responsibility, there's a federal statute in the United States that requires judges to detect and resolve any financial conflicts of interest that they might have in a case. So that's a regulatory component that comes into play. So why? So you have, as I mentioned, conflicts of interest. Another reason for disclosure is to determine whether or not the funder is controlling, and I use the term intentionally. It has many meanings, and we can certainly talk more about that. I think one of the later panels will address it further. But how much influence, control, directorial function is the funder providing in the case? There's different levels that are allowed. In some jurisdictions, funders are not allowed to control at all. In other jurisdictions, depending on the circumstances, they may. If the funder is investing in an equity context, then they are a part owner, and therefore they might qualify more as a party, and so control might be more appropriate. So these are some of the questions that come up in the control element. And then the last piece is to understand more about the influence of funding on the litigation and arbitration landscape. What does it mean to have a funder involved in a case? How does that affect the way the parties behave, the way the attorneys behave, and potentially the outcome? And it's tough to examine that question if you have no idea that there's a funder in the case. So that's another big reason. And there are others, but I'll stop there. Let my panelists jump in.
So before I address that direct question, I would like to kind of step back a little bit because for those of you that might not have experience with funding, like what are we disclosing? Like what are we talking about here? So in the funding process, the first step is due diligence on behalf of the funder. So we don't just hand out money like candy. So we do a lot of work, right? So we have to make sure that the funds that we are investing are going into good meritorious claims, right? Because we don't get money unless the claims are successful. So we want to only invest in good claims that we think are going to give us a return for our investors. So that due diligence process may vary depending on the funder that you're working with, but generally speaking, we look at the merits like you all would, right? I do most of my work in the patent context, so I'm going to give that to you, as an example. So I look at infringement, potential infringement, right? I look at the products, I look at the claims, I look at, the file history, I look at validity questions. Is there a 101 question we have to deal with? If there's a written description, I look at the file history, right? So all of this is, I do this on my own, but it's not also in a vacuum, right? I talk to the attorneys that are working on this case because I want to poke and prod them a little bit on answers and strategies and what they think about this. And as that moves along and it goes to the funding process, then all the monetary terms, right? The 40-page funding agreement comes into play, and that details how much money the funder is going to commit, how the lawyers get paid, and finally, amongst other things, how any proceeds, that are awarded will be distributed. Now, there's a lot of information there. Some people want disclosure of all of it, like wholesale, anything that you've talked to with a funder, anything that you've traded back and forth, including the funding agreement, including the amount of money, including the distribution, everything should be disclosed. And then there are other positions where it's just the funding agreement that should be disclosed, or certain portions, of the funding agreement that have been, properly redacted. I'd say that that people sometimes kind of conflate all that together. The case law so far has been overwhelmingly that the information and the communications between a potential claim owner and their lawyers and a funder has been protected under work product privilege. That has been I'd say the most prevalent way to protect that information and relevance. But I'll stop there.
Yeah, and the scope of disclosure will be informed by the purpose of disclosure. So conflicts of interest, let's take that as an example. Conflicts of interest has actually already been addressed in the federal rules. Federal Rule 7.1 requires disclosure of very basic information If you're a privately held company, for example, you don't have to disclose who your shareholders are, even though the judge might be buddies with those shareholders. And the comment to that rule explains why. We're not going to have overburdensome disclosure for purposes of conflicts of interest. But if you're worried about conflicts of interest, you don't need to know what the damages model in the case is, right? You just need to know, is there a funder, and is the judge, buddies or somehow invested in this funder, which, by the way, again, background rules, Canon 4 of the Judicial Ethics, prohibits judges from having business relationships and investments with parties likely to come before them. So if you're a judge and you're day trading in Burford, that's a really bad idea. You shouldn't be doing that. Then you need to think, okay, well, why am I looking for more detailed disclosure? And a good example, case just out of the District of Delaware, Design with Friends versus Target. Design with Friends was funded by my former company, Validity Finance, in a copyright infringement case against Target. Target didn't just want to make sure that the judge in the case, Judge Bibas, didn't have a conflict of interest because he wasn't an investor in Validity. They wanted to see the damages model, right? And so when we think about why are we seeking disclosure, the purposes beyond just the fact of funding end up implicating litigation strategy and jockeying for an advantage in that litigation.
And if I may, just build on that. In practical terms, I know we're talking about theory and law, but in practical terms, I often think about what the defendants would actually do with the information if it needs to be provided. So if the damages models was, disclosed. In most cases, these damages models, the claim charts, the whatever, especially the damages model, though, is very good for the plaintiffs, right? And the damages, as we all know, if you've been involved in litigation, a lot of facts change. So it's not ever going to be, Foursquare on Foursquare, right? It is going to be different. And so it's very, distinguishable, but it's also very beneficial to the plaintiff. So I don't know what you would do with it, even if you knew that the plaintiff at a certain point in time thought it was 100 million, but at trial they thought it was 150 or 75 million. What would you possibly do with that?
One more. So to build on that, because there's another piece that defendants might be looking for, which is the cost structure. So how much money is the funder willing to pay? So there's the damages model, which is how much is the claim really worth? How much does the plaintiff really think it's worth? And then there's how much does the funder think it's actually going to cost to pursue this claim to completion? And from a defendant perspective, to the litigation strategy point, they can say, all right, I know how much money this plaintiff has. I can push, this little weird sound, I can push to make sure that we, exhaust their resources or force them to the bargaining table. Oh, there we go. Maybe okay. Oh, yeah, they are all doing it. That's all right. You can all hear me. I've got teacher voice. So what is the amount, right? That's the limit on how much the plaintiff has to pursue this. And they can put pressure on the plaintiff to settle the case. And so that's another piece of the puzzle in terms of why they're looking for sort of
The other side of the coin is who doesn't have funding, right? So if I'm a defendant and I know that this poor plaintiff doesn't have funding, I know that I can drown them in motion practice. And so we also need to think about the implications for folks who maybe went through the funding process.
So a couple questions coming from the audience, but I want to touch, and they relate a little bit to the topics that each of you just mentioned. What are the arguments, like from a policy perspective, what are the arguments that you're seeing from the defendants about why do I need to see the damages model? What is the objective reason that that's important, that are being articulated to the court when they're asking for disclosure and discovery? And I guess to your point, Cindy, if you can't do anything with it, then why is there a fight to disclose that? I think those are both important, but flip side of the coin perspectives that the audience may benefit from.
Okay. So I've actually not been to the stage where we've gotten to why, like, damages model would be relevant. It's been really mostly couched in the terms of, like, kind of vagaries a little bit about control is a really big one. I think that from, I don't want to speak for anybody, especially the defendants, but when I've been at panels and I've listened to, you know, some of the bigger defendants talk about litigation funding and the scourge in the legal system, that they feel like, for example, the damages model would give them insight into how ridiculously high the damages or settlement could be, right? Like, that's one of the things. The other thing is that I heard is that they don't want to be unfairly categorized as Goliath to the plaintiffs, you know, David. They're being adequately funded, they're being amply funded. Why should the jury think that they're, you know, David with a slingshot when they actually have a cannon behind them, right? I mean, and the answer to that, simply in my head, is the ability to fund the litigation has nothing to do with the state of the parties during the infringement, right? It's just getting access. It's just getting to trial. It has nothing to do with how much resources you have. Normally, we have pretty strict bounds, depending on the funding agreement, about what the money can be used for, right? So unless it's like a pure, like, lump sum payment, it's, you know, $5 million for litigation expenses, it's for litigation expenses. It's not for rent for your company, right? And so it's all very prescribed. And so I have thought about this a lot. I've had a lot of discussions about why this would be necessary. I feel like it's more a generalized idea of it seems unfair to them that there's somebody there with money that they don't have information.
And so most of you are probably familiar with the attorney-client privilege and the work product. The attorney-client privilege protects from disclosure conversations between the attorney client, and the work product doctrine prohibits generally disclosure of materials prepared in anticipation. These are doctrines that date to long before the rise of modern third-party litigation funding. Why did our common law develop and eventually codify those doctrines? Because if you're going to think about bringing a case, you have to test that case, right? So any time that I fund a case, I point out, hey, I think this is the biggest weakness of your case, right? So now, and very quickly, just think of a hypothetical, right? You have a company that has an antitrust claim that's going to cost $10 million. Internally, they test this claim, they identify some weaknesses, they identify strengths, they bring the claim. If that company happens to have $10 million of retained earnings, such that they can self-finance, or if that company is publicly traded and can go to the equity markets on Wall Street or the recourse debt markets, it does not have to disclose whether it has funding, and there's basically no risk that that kind of work product is going to get used. Exact same plaintiff, exact same theory of the case, exact same damages model, everything else is the same, except the company's small. And Goldman Sachs want to take their phone call. They can't get equity financing, they can't get recourse debt, so they have to call Cindy. That's the only fact pattern that we're really talking about here, where now defendants are saying, oh, I need to be able to get that information because it was shared. That, I think, is where you get to, at least funders see some of the inequity there, where the corporate structure is somehow driving disclosure.
On one more point, which is, I don't know if this is working or not, but the other thing to consider is that people fear what they don't understand. And so defendants, they see funding, they don't really have a market for funding for themselves, and that's one of the challenges with third-party funding is it's mainly a focused market. At least at this time, there's a little bit of defense side funding, but it's not a major piece of the market. So many defendants, especially companies that are regularly and frequently sued, feel like there's this shadowy thing happening and they don't know anything about it and they want information. And if they don't get the information, their perception is that it must be something nefarious and we should seek to end or prohibit it. And so part of that is some of the reason I think why they are seeking this information. Whether they think that the claimant's claims are being inflated by funding, whether they think that the funders are funding frivolous claims, all of these fears are coming from the fact that they don't have as much information as they would like. And so I think that's also part of the dynamic.
A quick question coming from the audience, and this kind of touches on the David Goliath theme that each of you I think has talked about. Some folks want to know, does litigation funding, does it help everyday people? What are some circumstances or examples where funding fills a role in modern day litigation that actually affects individuals' bottom line, in whether that be a criminal context, eviction, a wage suit, you name it. Can you touch on that briefly? This is not, we talked a lot about the corporate commercial sense, but is there a role in another aspect of litigation?
I can start off. If any of you out there have a vehicle, you have car insurance, I hope. Your car insurance actually includes a duty to defend provision. And that provision says that if you are in a car accident, the insurance company will pay for your lawyer. That's a form, oh, thank you.
Working.
Awesome, okay, great, I can turn mine on. There we go, perfect. So your insurance company, your car insurance company will pay for your lawyer if you're in an accident, right? This is, in some respects, a form of third-party funding and perfectly legal, normal in our world. So imagine other aspects of your life as an ordinary citizen in which you might get into a dispute and might want or need support. So let's say you're a tenant and you're renting and you have a dispute with your landlord, or you're subject to eviction and you're trying to fight that eviction. Those are situations in which that's another situation which someone might have a need for funding because they clearly, if they're being evicted, they might not have the money to pay their rent. So they definitely don't have the money to pay a lawyer. Other examples include workers' compensation, as mentioned, as well as, let's say, a slip and fall case in a grocery store or other types of consumer situations that come up. So yes, and there's quite a bit of funding out there of consumers. It doesn't look the same structurally as commercial funding. That's another important thing to note. And another piece that I should mention that I think would be helpful to know about consumers is often the biggest challenge with a consumer is that they don't have the money to live while they're waiting for their case to come to a conclusion. And one of the prohibitions, if you've taken professional responsibility, you'll know that one of the prohibitions in most jurisdictions in the US is that a lawyer cannot pay their clients' living expenses. They can provide contingency fee funding to fund the case, but they cannot pay their living expenses in most states. There's a couple of exceptions, but most states. A third-party funder can do that. So sometimes in the consumer context, what the funder is providing is an upfront advance so that the client can make it through the case and not, lose their housing and make sure that they have the ability to live while they're waiting for their judgment. So it's very different from a commercial context in terms of the structure. And those are just a few examples.
John Mallow, who's one of the co-founders of Burford, wrote one of the seminal articles in this space, and he has this great example where he talks about someone being hit by a bus, right? And he says, look, if you're hit by a bus and you need medical help, historically, someone has a monopoly, and you have a claim against the bus driver, right? Someone has a monopoly on your claim, on your ability to settle that claim. It's the bus driver. That's the only person you can settle with, and so that person is able to extract monopoly pricing. And what does monopoly pricing look like if you're hit by a bus and you urgently need medical help today? It's a very low dollar amount that doesn't reflect the true value of your claim, but reflects your immediate need for capital. And so what Mallow argues is third-party funders come in and essentially break the tortfeasor's monopoly on your ability to settle. Instead of getting the 100K, let's say you have $1 million claim against the bus driver, instead of just settling for the 100K that you need today and extinguishing your claim, you can take 100K from a litigation funder and then go pursue the other 900K from the bus driver, right? So that's an example of how those economics can be very real to someone who is injured and pressure them to settle for less than the true value of their claim.
One other question coming from the audience that you touched on, Victoria, about how defense side funding works. And maybe I can make this a two-fer question and also just to ask each of you, how is the topic that we're talking about now, litigation funding in toto, relate similarly or dissimilarly to the insurance setting?
Well, I'll start,
Okay.
and others jump in. So as I mentioned, the defense side market for third-party funding is not that robust yet. But to your point about insurance has been around a long time, and almost every corporate defendant, or probably every corporate defendant, has some form of liability insurance or other insurance that helps cover them when they are sued. So in some respects, insurance is kind of the other side of the coin for defendants in this space. That said, I do think that there are some creative avenues out there where defense side funding has actually been provided. One of the examples that I've observed is in an international context in which there are governments of countries that are sued by corporate investors, and they enter into an agreement with a third-party funder to pay their expenses, and those cases are really, really expensive. Can be, 6 digits on the costs. Some of those cases. So in that sense, in that context, the defendant would sometimes pay a insurance premium or some other payment to the funder as a way to get the funder to pay their costs, and they sort of smooth out the litigation line item in their budget. But it's not a very prevalent form of funding, at least in my observation.
So I totally agree with you. I think that if people could really figure out a defense product that large companies would accept, we would be having a much different discussion about disclosure. And what I mean by that is the reason why plaintiff side funding works and defense side is more difficult is because at the end of a plaintiff side case, you ostensibly have this pool of proceeds, judgment or settlement, license, what have you. On a defense side matter, as a defendant that wins, you've just paid your costs and you're kind of back to where you were, and that's a win, right? So the problem is, how do you get money to pay the agreed upon cost to your funder if there's no pool of proceeds? I mean, that means that the defendant has to write a check, right? Which could be, depending on the size of the case and how much has been funded, that could be, that could be a lot. And that has traditionally been the issue. In the cases that I have seen funded on the defense side, I call them faux defense funding, because it's usually in the case of things like generic pharma cases where the defendant is a generic pharma company, but if they win, then they're opening up a market to them, right? So they can enter the market and put out their generic drug. And so that is going to be your pool of proceeds. It's with defense side cases that opens up some kind of known value. So if you have like a trade dress case against you as a defendant, and if you lost, you would have to expend $50 million redesigning all your McDonald's cups, whatever. That has sometimes been the case, but generally speaking, pure defense side has been a very difficult nut to crack.
Yes.
Do you mind if I add to Victoria's answer as a historical matter, not as a normative matter. I want to talk briefly about the relationship between the development of insurance law and the concepts that currently are in debate in third-party funding. But I do not want to say anything about the defense side third-party funding. I just want to talk about historically. Development of insurance in the United States, there were two important problems faced by the courts, both of which were solved in favor of the insurance industry for understandable reasons. One was whether or not insurance companies could, through subrogation, take over the claims of their insured damages for. Originally, the common law said no, that was a violation of the prohibition on champerty. Okay. That was eliminated as a matter of judicial decision-making, really having to do with the need to allow develop for the growth of the economy. About timely, it's the same question as third-party. Second was, later on, another 30 years passed, whether or not, matter of professional responsibility, lawyers who are being paid for by insurance companies on the liability side, on the defense side, could engage in exactly the same kind of shenanigans that people accuse lawyers doing today, taking instruction from a third party who's not the client, violation of the rules of professional responsibility. There too, the courts quietly and understandably decided in favor of the insurance industry. My point being, there are slow and evolutionary judicial doctrines that have evolved to respond to exactly the same legal challenges. I think they got the right outcomes there. I see no reason why what's good for the gander isn't good for the goose. The last point I'm going to make is, to the extent something like this, when it's all historical, it's not normative. They say, well, but there's a normative difference. Insurance companies are not seeking to make profit from the lawsuit. They are merely seeking to protect the indemnification that they promised by contract to pay out before the accident. My response to that is, but insurance companies are interested in making a profit. That is, they wouldn't actually be indemnified, the insurers, unless they get profited from the business of insurance. I don't really understand why that distinction, that difference is a distinction.
I could just amplify 2 points on that. One is, in many of the cases that are funded, if we think about funding as a party contracting with a third party to share the risk of that case and the expense of that case, it always happens on the defense side. It's called best business practices. It's called insurance. So many of the same defendants that are seeking discovery of the plaintiff side funding are themselves insured, have themselves given up control. And then the second is, so Certum's business is a little bit interesting and unique because we do both funding and insurance. We've actually done more insurance deals than funding deals, and almost all of our insurance deals are on the defense side. So if you're a defendant and you're being sued for $50 million, you can actually, if the risk is right, buy an insurance policy from us, where if the case loses, we would pay. And so to Victoria's point, and Tom Baker at Penn makes this point as well, that defense insurance kind of is third-party funding, and it's been around for a while.
Yes, and I'll just add one more and thank Professor Tony Seebach for his comment. He's a distinguished third-party funding scholar who we'll hear from later today. Now, insurance and third-party funding are kind of getting together, and they're saying, hey, we've got very similar thoughts about how to engage in supporting clients. Let's partner. So I think in the future, we might eventually see some sort of convergence here. Not sure what that will look like, but it will be fascinating to watch.
It's probably a good segue to the discovery and disclosure topic specifically, and your views on that. And maybe we can use insurance as the takeoff point for that. And so maybe one of you might want to take the lead on, first in the insurance context, what is required in terms of disclosure and discovery, and how do you see that being analogous or not to what may eventually be required relative to third-party funding?
Well, I can start with something that would be very familiar to all of you law students out there who've taken civil procedure. Rule 26A 26A of the Federal Rules of Civil Procedure requires defendants to disclose for inspection and copying, so the full agreement of their liability insurance policies or any insurance policy that would be paying the judgment if they were to lose the case. So this is often where the conversation starts with respect to the analogy to insurance and the disclosure of third-party funding. And this is often why those arguing for full disclosure of the funding agreements point to Rule 26A and say if funding is so similar to insurance, you should disclose the full funding arrangement and all the details just like the defendants are required to do under Rule 26. And I think that argument is not quite aligned with the purposes of Rule 26. Rule 26 is focused on ensuring that there is enough capital and for the claim itself, the actual value of the claim to be paid. And so letting the plaintiff know the limits of the liability insurance policy so they understand that the defendant can't sort of lowball them in certain ways. So that's the purpose, one of the purposes behind 26A. Funders don't pay claims themselves. They pay costs. And that's a key distinction. And so while there are similarities, it's not quite exactly apples and apples for funding and insurance. So I'll start there. There's more to say, please.
I don't have anything to add to that. I thought that was absolutely my thoughts on it.
I'll add something very quick, but I agree with all that as well. So the insurance analogy is interesting. So the general rule is no disclosure. Insurance is the exception. The question is whether funding is sufficiently similar to insurance to warrant the same exception. But then I think the other point to kind of layer on top is if they are similar, are we actually going to have parity across the board? So for example, there are a lot of background rules and privileges that the courts have developed and extended so that as a general rule, although you can get the fact of insurance, you're not getting the work product of the insurer. The efforts to disclose funding as an analogy to insurance don't accept that equivalent with insurance. And then the second feature is insurers are allowed to control. So we say we disclose insurance because you can control. And it's the flip side. If you look at Connolly's rule and the District of New Jersey's rule, we have to discover funding because you can't control. So there's kind of a multi-pronged equivalence that we need to think about, right? If we're going to disclose because they're analogous, are they also analogous to have the same privileges and have the same control rights?
Couple great topics. I want to touch on those a little bit more in terms of if we are heading towards a world where there may be some mandatory or minimum disclosures, and a few things that have been brought up, an earlier question, conflicts of interest, control, et cetera. What do you all think should be, if any, mandatory disclosures or discovery should be allowed of third-party funding? And what are we seeing? There's been two very widely published examples in New Jersey and Delaware, but where do you see that going?
I don't know where it's going to go, but I can tell you that if disclosure is necessary for conflicts, for those kinds of issues, a in-camera disclosure to the court should be sufficient. I don't necessarily think that, on practical points of view, that a defendant will do anything with it, right? Like, I don't think you can. I don't know what the end game is with all that information other than to have an unfair advantage. If you know that we've only funded up to $10 million, but you can really make this case really expensive, so it's $20 million, that's just, there's no probative value to that. So I do think that to the extent that this disclosure is going to go the way that, Judge Connolly or New Jersey has done it, that it's sufficient. And people ask me, like, why? If you have nothing to hide, why would you do that? I'm like, first, it's not, generally speaking, it's not my information. It's, somebody else's information. And, I will tell you, speaking personally, I'm very proud of the cases that I fund. I do a lot of work on it. And, it's not, and it's a lot of responsibility, right? Because I'm taking investors' money and putting into something that is inherently a very risky proposition, but we try to do our best to try to ensure that they're going to get a return, right? So generally speaking, I'm very proud of the cases, and if I could, I would. But in our experience, what has happened is that it's become a sideshow. There's been discovery. They've been wanting to have depositions. They're, for all things that I think are, at the end of the day, irrelevant.
I agree with that, I think Eric from, on the consumer side has done really great work. If you look at when they've engaged on the issue, some of the statutes that have been passed regulating consumer funding are actually very good in terms of a lot of these issues. They'll explicitly protect attorney-client privilege and work product. I would personally love for the words litigation finance to appear in the federal rules of civil procedure in a way that sanctions them. I think that's great for our business. I think that we should stop at the point of disclosing materials that generally are not disclosable. And the last thing I want to say on this is one thing to recognize. If you accept the premise that litigation finance can help litigants that have strong claims, these efforts to essentially raise the barriers to get funding, they raise the cost of litigation finance. So if I can, and I don't control the claims, but if I could offer better pricing. If I knew that I wasn't going to have to face a barrage of discovery requests, I could offer better pricing, right? Because the risk then associated with the case goes down. And so I do think that for everyone, I think getting clarity around this can actually make the industry be a lot more efficient and serve our clients even better.
I completely agree. I think finding a middle ground will be important. And I think that's one reason why the Federal Civil Rules Advisory Committee has been petitioned multiple times over the past decade to make a rule on funding, and they still haven't done it. They've pledged to examine the issue, which is create a committee and think about it, which is a good step. I agree that clarity will be helpful. I don't know if we're going to get it from Congress. I mean, they certainly have proposed a bill in the House, but I don't think it's going to pass. So at some point, we will get clarity on the general disclosure question. Just to be a little provocative, I'll drop another disclosure question in here that I don't think we're going to get clarity on anytime soon. One other consideration that the federal government in particular is concerned about is national security. So what they've raised as an issue is that there are some view that there might be nefarious entities outside the U.S., foreign adversaries, that might try to invest in litigation funders themselves as a way to get into cases and get confidential or privileged information that they couldn't otherwise get, I guess, some other way. This is the hypothesis. I have yet to see an example of this actually occurring. So I don't know one way or the other, but it is an interesting question because it's different from the classic disclosure problem that we've been discussing, which is about how funding is affecting the litigation system. This is a totally different direction. I haven't seen any proposals of regulation in this that would aim at that, but it is interesting to see what's on the minds of our federal regulators with respect to their questions that they have about funding.
And that's a great topic, which was exactly where I was about to go to next, which is we talked a lot about just the general economics and why litigation funding and finance, plays a role in modern litigation. There's this entire other side of it, the geopolitical, social influence, et cetera. And although not true of all funders, some funders are drawing from a group of either accredited investors, pension funds, et cetera. Maybe Will and Cindy, you can speak to this sort of geopolitical risk, national security risks. Do you view that as a real issue for your organizations and litigation finance at large?
Well, the short answer is no. The longer answer is, so one, obviously, there's been no evidence, right, to support any of this that might happen. If you're China and you're Russia, there are a whole lot more effective ways to undermine the U.S. national security than to become an LP in Longford and somehow influence their case selection. But I want to give you another example just to show you how it's like when we talk about least restrictive means analysis, right, in constitutional law, there needs to be some basic fit between the concern and the regulation designed to address that concern. Consider, for example, a litigation brought by Uber when it was a privately held company against the city of Seattle with respect to driver regulations, right? So trying to invalidate a democratically elected law. Well, Uber was backed by SoftBank, right, which is a foreign entity taking Saudi money, also has large stakes in a lot of Chinese companies, and none of that was disclosed, right? Was there someone from SoftBank or from China or Saudi Arabia that was spurring Uber along as a controlling shareholder potentially of Uber to invalidate this democratically elected law? I don't know, maybe. None of that is addressed by any of these regulations. So if you really are Xi or Putin or their underlings, and you think that interfering with the US litigation process is a way to give you an advantage, you're not going to do it by becoming a third-party funder. You're going to do it in so many other ways. And so, again, going back to con law, the poor fit between the purported concern and the solution, I think, suggests that there are other reasons that people are proposing these, but that this is a more convincing argument in our political arena.
I think just practically speaking, first of all, I agree with everything that Will said, but if you were to be involved with, the bigger litigation funders like Certum, myself, Burford, Omni, if you invest in a fund, so if you're a foreign sovereign and you invest into a pension fund or whatnot that becomes an investor as an LP, first, I'm not aware of anybody that discloses confidential information to their LPs, right? It is generally, claim owner filed a patent suit in a district court asserting 3 patents in the telecom field. Like that's pretty much, and it's a project name, Project Dragon, I made that up, right? Something like that. That's what they get. We as funders don't get privileged information, right? We're not privy to that. We're not going to get that. The attorneys certainly aren't going to give it to us. We're not going to ask for it. So for there to be an argument that this is all like really, important technical information is going to flow all the way to the LPs and then to the foreign sovereign, there's easier ways for, China to get into a company than through this convoluted means.
Yeah, maybe I can just jump in here because I know we're going to run out of time here just shortly. Brass tacks, and because I'm not sure if this is clear to our audience in terms of the actual implementation of funding arrangements. What does that look like? You're not buying a claim and really a shadow boxer, they're controlling the claim. Can you talk a little bit about how agreements are structured in such a way that it does create that arm's length between, especially even between just the funder and the lawyers or the actual client, but certainly the limited partners as well?
So I can only speak for Longford, but one, we have a provision that explicitly states that Longford will not influence lawyers or their claim owner, that we have no say in settlements. We organize our funding agreement to make payments based on timing, months, or milestones, and when requested. There is no right to control people. I always make this example. After I fund you, you could settle for a sandwich and a Subway token, and I would be unhappy, but you could do it. Right? And part of the due diligence process is me making sure that there's reasonable expectations, either too high or too low by the claim owner, because that's where it ends. for me. And also, what we don't talk about it, but it's kind of implied all the time, is that the attorneys that are involved in this have their ethical obligations that sometimes people think that they just throw away when they enter into or are representing a party that's funded. They have their ethical obligations to their client. We are not their client. They are very clear on that, right? We are very clear on that. So this idea of control, I think is something that's already been debunked for the most part, but it's a very seductive argument.
Yeah, just quickly, I'll agree with that. Every agreement I've ever signed explicitly disclaims control and explicitly reaffirms the lawyer's ethical obligations to put their client first.
I'll just add on, in the IP space, sometimes there's actually 2 layers of law firms where the client has their law firm that's actually proceeding in the case and representing them, and then the funder might hire another law firm to interface. So it's law firm to law firm talking to provide an extra layer of protection. Now, that's, of course, in the very expensive cases. It's not in sort of a smaller case. But it shows even more so how the industry is trying to say, no, we're keeping our arm's length from the information that would be sensitive or confidential, trade secrets, all that kind of stuff.
So we've talked a little bit, actually, I think mostly really about the U.S. context and a couple progressive jurisdictions. For those who don't know what New Jersey is doing and one judge in Delaware is doing right now, can you talk a little bit about that? And how does that compare to the international context where litigation finance has been around for a lot longer period of time than it has been here domestically?
So thank you. So so what's happening in New Jersey and Delaware is interesting because it's a proactive opportunity for judges to, particularly in the Delaware context, Judge Connolly, to say, here's what I want to see in terms of a disclosure rule or disclosure mandate. What's interesting about it is what they're asking for. So in the Judge Connolly context, at least in terms of the judicial order that was made, where for his particular, if you appear before Judge Connolly, this is what you have to do. He was really concerned about the investor question. So he wanted to know who are all your investors, and I believe the original formulation was going all the way back to a human being. So if you have an LP and an LLC, and you have to disclose everybody in the chain until you get to a human being. I think that's a outlier viewpoint in terms of the level of disclosure requested by jurisdictions in which disclosure is currently required. So the other jurisdictions out there would include, the Northern District of California requires disclosure of funding, and West Virginia and others. So it's not at the level that Judge Connolly is requiring. So that's one example. With respect to the New Jersey context, I think that it is, if I recall correctly, it's by statute in New Jersey. And so I think, not by statute, I'm sorry, I may be sorry, my brain is having a little bit of a moment. Just a local rule, thank you. Sorry. So local rule on disclosure of funding in the court. I may be confusing states, I apologize. So anyway, it's widely varied, jurisdiction by jurisdiction, state by state, in some context, judge by judge. So I'll leave it there.
And the international arbitration context is interesting because I don't know if the law students are familiar with international arbitration, but it's typically private attorneys who are adjudicating the dispute, right? So let's say an American company contracts with a French company. They might agree that if they have a dispute over the contract, the International Chamber of Commerce will adjudicate the dispute. There'll be 3 lawyers, one selected by either party, and then a chair selected by the 2 of them. Well, those aren't judges, right? Those are typically practicing lawyers who might have their own cases funded by a funder, or who might have who might perform diligence for funders. And so in that context, it makes sense to disclose to the arbitrators whether there's funding, because the arbitrators are much more likely to have a potential conflict of interest than a federal or state court judge. And so what we've seen in the arbitration context is a move towards disclosure of the fact of funding and the identity of the funder to eliminate that much stronger justification of ferreting out conflicts of interest.
Anything else to add, Cindy? Okay. What can we, where there's a much lengthier development of litigation finance internationally and particularly in the arbitration context, are there any approaches in other jurisdictions that U.S. courts or Congress can learn from as they consider and grapple with this issue of disclosure and discovery here in the U.S.?
There are many jurisdictions out there in the world that have codes of conduct for the funding industry. Hong Kong has a code of conduct. The government of Malaysia is about to issue a code of conduct for its funding industry, as it's about to issue regulations to allow funding in that context. And so there are others. I think what's fascinating about it is the international arbitration context is much more top of mind outside the United States. U.S. regulators are not as well versed in international arbitration and don't typically address it in any regulatory contexts. They're mainly focused on domestic litigation here in the U.S. And the other thing I would say is, outside the U.S., there's a lot more funding of mass and representative actions, which we kind of don't really have as much in the U.S. We have class actions here that do get funded, not necessarily directly to the class, but to plaintiff side law firms. Outside the U.S., there's a lot more actions involving mass or representative plaintiffs, which what that means is instead of having a class definition, you actually do have enumerated parties in the case, and there may be several of them. And sometimes in the European context, there's a corporation that sort of gathers those claims together, gets third-party funding, and proceeds with the case. So that's something that is addressed in some of the regulations outside the U.S. as well.
I'm just going to pick up this question that I think we've probably largely covered, but getting towards the end, and then I want to open it up to the audience on any further questions. Very broad question, but what do you each see as the main benefit of litigation funding? Like, what benefits does it provide to society at large?
So my friend and co-author Sunil is here, and we just wrote an article that has a little bit of a different approach maybe or take on one of the benefits. So in addition to the litigation benefits, what we argue is there's a lot of benefits to the business community to litigation funding. That if you conceive of litigation funders as essentially another capital market, right? If you have need for capital, you can raise money from us to pay those legal bills so that the $5 million you otherwise would use, you can invest in your core. Or we talked about working capital just to monetize your claim to run your business, right? We have the best capital markets in the world, but there's a lot of literature about how these capital markets work best for large companies that have access to liquid debt and equity markets, primarily on Wall Street. Small and medium-sized enterprises are typically stripped of access to those kind of capital markets. They either can't get financing or they can only get very expensive, cumbersome financing. So I would say that in addition to these litigation benefits, we also need to recognize that third-party funding ought to actually increase the competitiveness in our larger business markets. And the last thing I'll say, just a quick example, we get approached pretty frequently by companies that are going to raise equity finance, but say, hey, I've also got this valuable IP or this valuable legal claim, instead of diluting my existing shareholders and raising $5 million of dilutive equity capital, I'm just going to raise litigation finance. And so I think that as much as this is a topic of conversation in law schools and the Judiciary Committee, I think it also ought to be a topic of conversation in the business schools and the Financial Services Committee, because I think it has a lot of benefits there that have not quite yet been sufficiently tackled.
So just building on that, my personality is that I am very much, I can think about the theoretical and the societal benefits, but, most of the people that I work with as a funder are smaller side companies, like that really need every penny, or quite honestly, inventors, because I work in that patent space, inventors that have been unsuccessful in the market, right? So they had this idea, they were either pushed out of the market or they couldn't raise the capital or for whatever reason, right? So without my money, that inventor, that solo inventor could not bring this case. There's no doubt. There is no doubt in my mind that that would not happen without my funding. And two, the medium to small company, local company, right? I was in-house as a general counsel. I was the general counsel with a CEO that was very litigious. So it was very fun, but also extremely stressful because we were defendants and plaintiffs on multiple cases. And if I had an inkling that there was litigation finance available to me, I would have been all over that. It would have been remiss of me to not consider the benefits of that because the risk is so large. And I know it's really hard as law school students to understand the gravity of the risk. Like one of the biggest thing I've ever said to my board of directors is, we could be 100% right. And I'm telling you that we are 100% right, but we could still lose. Like that is a thing that could absolutely happen, right? And that is why funders are in the space, because it's not just a matter of, if I put in this $5 million, I know I have a great case, I'm going to win. It is the risk that cannot be borne by them. So we are out there. So when I see success, when I see, my partners doing very well after 3-4 years, of a long road, that's the benefit to me.
I think one of the key benefits that third-party funding provides is it highlights a potential solution to a big problem that we have in our dispute settlement system, which is the number of people and businesses who cannot afford it. It's becoming ever increasingly more expensive, and at some point we have to ask ourselves, and third-party funding sort of makes us ask ourselves, is there a problem in our system that we need a whole industry to arise to provide financial support to entities and individuals that otherwise would not be able to bring meritorious claims? Is there something not quite fully aligned in terms of the interests of our legal services industry, the costs of litigation, the expanding scope of evidentiary costs and things like that? It gives us that opportunity and provides, I think, one way to have a solution.
So I think we only have a few minutes left here before the break. So I don't have any further questions coming in off of the Slido app, but if we have any questions from the audience, and I don't know if we have a broader broadcast, but you can still send questions through the app. Yes, Professor Anderson.
So I've looked at the disclosure requirements in Delaware, and we were talking last night about those. Judge Collins had the disclosure requirements for 2.5 years. What have we seen from the disclosure he's asked for? So we should know something about the litigation funding. What have we seen?
From my perspective, I don't know, Will, if you've seen anything else, nothing really has changed. We filed our disclosures, or we've seen disclosures being filed, and then not really anything much more. But Will?
I think we need to read your forthcoming article on that. But yeah, I think that's right. I mean, and the District of New Jersey is another one. It's kind of interesting because it's less of kind of a patent venue. It's a tiny percentage. I think the last check was, I mean, Andrew probably knows better, but 16 to 20, maybe at most, disclosures. Yeah. Over hundreds of cases that are filed, probably 1,000. Westfleet's industry report concluded there were about 300 litigation finance deals last year. So it's a very small number of cases, to put it in context. We say no.
They asked for, so in New Jersey, you only see positive response, right? So you don't see the thousands of no responses because they don't submit. But someone has to actually determine whether or not to respond or not, right?
Correct, right, yeah.
We don't know what kind of burden it makes the parties.
Right. Right. But it's a very small percentage of cases that are funded. We say no to 95% of what we see. And if anything, we probably deter people from filing suits more than we help them. Because if we say no and Cindy and Andrew say no, you're not going to pay your own money to pursue that case.
That actually highlights another interesting dynamic, which is the amount of sort of counseling and advice that goes on from funders that are talking to parties who either have an unrealistic size of their claim, or they think they have a really big chance of winning when they're actually wrong. And so there's really not a way to measure that, but I actually think that's having a huge measurable impact on our system of justice. I don't know if there would be a way to learn more about that, but I think it's a fascinating dynamic.
And I'll go moderator, turn panelist on that one. I do think that's actually a really important dynamic of litigation funding and also in the contingent fee space. And you touched on this, Cindy. A big part of that vetting process is also vetting who you're funding and what their expectations are and whether or not that aligns with the economics and business case for any particular case. We as lawyers do the very same thing. Particularly in that context where somebody is not coming out of pocket with their own dollars, it's nearly as critical, if not more critical, to ensure that everyone is aligned, from the lawyers to the client to the funder, because you're all shooting towards some particular end goal, but at the end of the day, your client, both in a contingent fee context as well as a funding context, is the ultimate arbiter of do I or don't I settle. And so, if you have a misalignment with your client, that can end up with some dynamics that aren't great in the funding context, contingent fee context, that are different from an hourly context. I think we've exhausted our time, so really appreciate it. Thank you, everyone.